Welcome to our latest exploration. We're diving into the stories behind the headlines, aiming to give you the clearest view possible. Today, we're looking at a really significant legal battle. It's been casting a shadow over the digital asset world for, what, almost 5 years?
That's right, nearly 5 years.
And it just reached a major conclusion, finally. This whole saga, it's actually brought some much-needed clarity, wouldn't you say?
Absolutely vital clarity, yes.
So our mission today is to unpack all that. We'll look at the key moments, the twists, and really focus on what this final resolution means for a major player, XRP, and, the wider market.
Indeed. And this case, it's been watched incredibly closely. I mean, from every angle, individual investors, huge institutions, everyone had eyes on this.
Why so much scrutiny?
Well, because the outcome was always going to have ripples, excuse the pun. It had the potential to really shape the regulatory landscape, and either boost market confidence or, well, dampen it. So this clarity we finally have, it's a big deal for many. It offers a level of certainty that's been missing for a long time.
Okay, so to really get why this conclusion matters so much, we need to trace it back. Can you walk us through the timeline? Where did this all begin?
Sure. The starting gun really fired on December 22nd, 2020. That's when the U.S. Securities and Exchange Commission, the SEC, sued Ripple Labs.
Ripple Labs, and its executives too, right?
Yes. CEO Brad Garlinghouse and co-founder Chris Larson were named as well. It landed like a bombshell just before the holidays.
And the core accusation.
The main claim was that Ripple had sold about $1.3 billion worth of XRP tokens without registering them as securities. That's the crux of it.
$1.3 billion.
Okay.
And Ripple's defense, what do they say immediately?
Their counter was pretty forceful right from day one. They argued XRP isn't a security at all. It should be treated as a currency.
Which would mean?
Which would mean, in their view, it falls outside the SEC's registration requirements. So it was a fundamental challenge to the SEC's authority over XRP. That core disagreement, what is XRP, that set the stage for the whole fight.
So the battle lines were drawn.
Yeah.
What happened next? Any key early moves?
Oh, yeah. The legal gears started grinding almost right away. Early 2021, Ripple filed a motion to just dismiss the case entirely, challenging the SEC head-on.
And the SEC?
Well, the court actually granted the SEC more time for discovery, extending their deadline to gather evidence. So it was clear pretty early on, both sides were digging in for the long haul. No quick fix was likely.
Right, settling in for a marathon. Now, as things progressed, there was a lot of talk about the Hinman documents. What were those and why were they such a big deal in the case?
The Hinman documents. Yes, they became a real focal point. There were key court rulings about them in April and September of 2022.
Okay.
These weren't just random emails. They included internal SEC discussions, drafts relating to a 2018 speech by William Hinman, who was a top SEC official then.
And in that speech?
In that speech, Hinman expressed his view that Bitcoin and Ethereum weren't securities. So, Ripple's lawyers were hunting for addends in those documents, hoping to show the SEC itself, internally, maybe didn't see all digital assets as securities.
I see. To bolster their argument that XRP shouldn't be either.
Exactly. Getting access to those internal discussions was seen as a pretty significant win for Ripple's legal team at the time.
Makes sense. If the SEC had internal doubts about classifying similar assets, why treat XRP differently? But then came a really massive moment, July 2023, Judge Annalisa Torres's ruling. Tell us about that.
Right. This was the turning point, a really crucial ruling, and the details matter a lot. Judge Torres delivered what most people call a mixed verdict.
Mixed how?
Okay, so she found that Ripple's institutional sales of XRP, we're talking about $728 million worth, sold directly to sophisticated buyers like hedge funds, did violate securities laws.
Okay, so a win for the SEC there.
On that specific point, yes. But, and this is the really important part, she ruled that sales of XRP on public crypto exchanges to regular retail investors did not violate securities laws.
Wow. Okay, that's a huge distinction.
It is. It created this clear legal line based on how the XRP was sold and arguably who was buying it and what their expectations were.
That's fascinating. But just for clarity, how does a court draw that line between an institutional sale and just me buying some XRP on an exchange? What's the legal difference there?
It's a great question. It really hinges on the context of the sale, following the logic of the Howey test, which is the standard legal test for an investment contract.
Okay.
For institutional sales, Ripple was directly soliciting buyers, providing info. These buyers were sophisticated, likely expecting profit based on Ripple's efforts. That fits Howey. But for exchange sales, the judge reasoned that retail buyers weren't in a direct contract with Ripple. They were just buying on an open market. Their expectation of profit wasn't necessarily tied directly to Ripple's ongoing work in the same way. It was more like buying a commodity.
Interesting. So the mechanism of the sale was key.
Precisely. That distinction is what makes this ruling so significant, potentially offering a kind of roadmap for other digital assets.
Okay, so we get this landmark ruling in mid-2023. Big clarifications, but the case wasn't completely done yet, right? What happened moving into 2024?
Correct. The case moved into the remedies phase, basically figuring out the penalty for the institutional sales violation that the judge did find.
Right.
So 2024 involved more legal processes, testimony, financial documents being submitted. Ripple had to provide audited financial statements to the court. It was all about nailing down the consequences.
Which leads us to March 2025. What was the big news then?
That was another huge step. In March 2025, both the SEC and Ripple agreed to drop their appeals of Judge Torres's 2023 ruling.
So they both decided to stick with that mixed verdict.
Exactly. That effectively cemented the ruling. The core legal question about XRP's classification security for institutional sales, not for retail exchange sales, was now settled law. That main fight was over.
Finally bringing that regulatory certainty everyone was waiting for.
A huge amount of certainty, yes.
And then the money part. The
Yeah.
final financial resolution came in May and August 2025.
Yes. In May, they initially agreed on a settlement figure, and there was even an attempt to get the penalty lowered from $125 million.
But the judge didn't go for that.
No, the judge rejected the lower amount, emphasized that Ripple needed to comply with securities laws going forward. So ultimately, on August 7th, 2025, Ripple agreed to pay the $125 million fine.
And how is that broken down?
It's interesting, $50 million goes to the U.S. Treasury. The other $75 million, which had been sitting in escrow since June, was actually returned to Ripple.
Oh, okay.
So, yeah, that officially closed the book on this nearly 5-year legal saga.
So after all that time, all the uncertainty, the main legal questions are settled. XRP status, depending on the sale type, is now clear. The battle's over.
That's the bottom line. The mixed verdict stands. And even with its nuances, it's widely seen as a profoundly positive outcome for XRP and potentially beneficial for the broader crypto market, too. It sets a clearer framework.
Okay, so the legal dust finally settles. The big question then, what was the immediate market reaction? What did we see happen right after the news broke?
Well, the most immediate thing was a noticeable jump in market confidence. You could almost feel it. And perhaps more importantly, a renewed sense of interest from institutional players.
Why the institutional interest specifically?
Because regulatory clarity is huge for them. Removing that massive legal uncertainty makes digital assets like XRP much less risky from their perspective.
But
It sort of opens the door for more traditional finance to get involved more seriously.
makes sense. And XRP's price itself reacted pretty strongly, didn't it?
Oh, absolutely. It surged about 11% in less than 24 hours, went from around $2.99 up to $3.30 pretty quickly.
Wow, 11% in a day. What does that immediate jump tell us about how, say, Wall Street views this kind of regulatory news?
It tells us clarity is king, basically. That 11% jump isn't trivial. For institutional investors, less legal risk makes an asset way more appealing. And that price move pushed XRP's market cap back above $180 million.
Which put it back among the top cryptocurrencies.
Yeah, reestablish it firmly in the top 5 by total value. That's a position it held before the lawsuit cast that long shadow. So it really signals a strong comeback and, a vote of confidence in its newly clarified status.
And you saw figures within crypto reacting positively too. I think Ripple's own legal chief, Stuart Alderati, basically said, okay, this is behind us, now we can focus on business.
Right, a clear signal of relief and readiness to move forward.
So, moving forward, let's talk about one of the really exciting potential consequences. XRP ETFs, exchange-traded funds. The odds seem to have jumped dramatically.
They really have. Post-settlement, the estimated odds for an XRP ETF approval shot up to around 77%. That's a significant boost in confidence.
And some experts are even more bullish.
Yeah, analysts like Bloomberg's Eric Balchunas and James Seifert, they've put the probability closer to 95%.
95%. Why such high confidence, specifically for XRP, compared to maybe other cryptos?
It goes back to that crucial part of Judge Torres's ruling. That retail sales of XRP on exchanges are not securities. ETFs are primarily sold to retail investors on exchanges.
So the ruling directly addressed the legal status relevant to ETFs.
Precisely. It gives XRP ETFs a unique legal footing that many other crypto assets still facing regulatory ambiguity just don't have right now. It removes a major potential objection for regulators like the SEC.
Okay, that clarifies the optimism. And it's not just talk, right? Big players are actually filing applications.
Definitely.
Yeah.
We've seen filings for XRP ETFs from major asset managers, names like Grayscale, Bitwise, WisdomTree. That shows real institutional commitment, not just speculation.
There was also that flurry of excitement around August 8th, speculation that BlackRock might jump in with an iShares XRP trust. That got a lot of attention.
It certainly did. BlackRock is, a giant. Their entry would be massive news.
Right.
But it's important to note, BlackRock themselves pushed back on that specific rumor. A spokesperson denied any current plans to file for an XRP ETF, or even one for SOL, for that matter.
Okay, so maybe not immediate from BlackRock.
Right. But the bigger picture here, I think, is that the lawsuit's conclusion, regardless of one company's immediate plans, has cleared a huge roadblock. It's created a much friendlier environment overall for crypto financial products. That boosts long-term confidence across the board.
What a journey it's been from this deep legal fog to, well, a much clearer path ahead for XRP. It feels safe to say this outcome is seen as a really positive step for the whole digital asset space.
Absolutely. And cases like this, even though they're long and complicated, they are so important. They force regulatory clarity, and that clarity is what allows innovation to happen safely and encourages bigger institutions to participate seriously. It's all about defining the rules of the game.
It really is about defining those rules.
Yeah, so everyone knows where the lines are and how they can build within them.
So as we wrap up, here's something for you, the listener, to think about. Given this very specific, nuanced resolution for XRP, that distinction between sale types, what lessons can we really draw? How are traditional regulations managing or maybe even struggling to keep up with digital assets? And looking forward, how might this kind of approach shape the future for other cryptocurrencies as they try to integrate more deeply into our global financial system?